Good morning. My name is Philip Munoz. I'm an associate professor in political science and a concurrent faculty member at the law school. I direct the Tocqueville program and the Constitutional Studies minor, and it's my pleasure to welcome you to day 2 of our symposium, Religious Freedom Under Obamacare. I'm just delighted that you're here. I'm delighted that many of our visitors made it. I heard on the news this morning, yesterday set a record for the most rain ever on that day. So I know a lot of you traveled and had a difficult time making it here, so we're very glad that you're here. I just want to start by thanking a few people that helped us put together this event. Here on campus, the Office of Research is a sponsor, and today's event is part of Notre Dame's official Constitution Day celebration. The Center for Ethics and Culture and its director, Carter Sneed, one of our panelists this morning, helped us put this together. The Institute for Scholarship and the Liberal Arts, and then most importantly, our good friends at the NAPA Institute. We have the founder, Tim Bush. Tim helped co-sponsor all this, made this possible. The donuts you're eating are from Tim. So thank you very much, Tim.
There's something special about those donuts.
Some of our benefactors are here tonight. I introduced them yesterday, but let me say a special thanks again to Bill and Jody Oros. Their generosity founded the Tocqueville program, so thank you for joining us, and thank you for all that you've done. We're going to try to save as much time for discussion today. You know, this is, we're going to have some presentations, but really this is meant to be a discussion. So I'm going to step out from behind the microphone. Let me introduce J.C. Sullivan. J.C. is one of our Tocqueville Fellows this year, and he's a Constitutional Studies minor, and J.C. will introduce our panelists. J.C.
Thank you, Professor. Good morning, everybody, and welcome to the second day of our symposium on religious freedom under Obamacare. Continuing the conversation started by Mr. Bill McGurn last night, we are joined this morning by Richard Garnett and Carter Sneed, who will discuss the HHS lawsuits in for-profit businesses. Professor Richard Garnett is a professor of law and concurrent professor of political science at the Notre Dame Law School. He is a leading authority on questions and debates regarding the role of religious believers and beliefs in politics and society. Professor Garnett is the founding director of Notre Dame Law School's new program in Church, State, and Society. He has also served on the Notre Dame Task Force on Catholic Education and consults regularly with the Alliance for Catholic Education. Professor Carter Sneed is also a professor of law at Notre Dame Law School and is also the William P. and Hazel B. White Director of the Center for Ethics and Culture. Professor Sneed's scholarly works have explored issues relating to neuroethics, stem cell research, abortion, and end-of-life decision-making. In addition to his scholarship and teaching, Professor Sneed has provided advice on the legal and public policy dimensions of bioethical questions to officials in all 3 branches of the U.S. government. Without further ado, please join me in welcoming Professor Garnett and Professor Sneed.
Thank you very much. Thanks to everyone for coming. Thanks for those who made it possible. Thanks to my co-panelist and my friend Rick Garnett and Phil Munoz, who is the impresario of this event. The division of labor this morning, as Phil said, the aspiration here is to have a conversation. It's a symposium, it's a discussion, it's not a lecture series. And so what Professor Garnett and I are going to do is just to sort of set the table a little bit with a description of the law that we're all discussing, as well as the reaction to the law. My role here will be to provide an overview of the origins and application of the Affordable Care Act, Obamacare's contraceptive mandate, and then Professor Garnett will discuss the lawsuits by private businesses in response to that mandate. But as I said, we want to leave ample time for conversation and exchange, so these will be brief presentations. So, to begin with a brief timeline, in 2010, March 2010, the Affordable Care Act, otherwise known as Obamacare, passed, was signed into law, and it was a very large statute, over 2,000-page statute with a whole variety of mechanisms that vested discretion in the authority of the administrative agencies, including especially the Department of Health and Human Services, to make policy in a directed way to fill in the gaps that this broad stroke statute had left in place. And among the various directives that the Affordable Care Act, or Obamacare, provided is that group health plans must cover preventative services, certain preventative services, without cost sharing, meaning no co-payments, no co-insurance, no deductibles. But then the statute itself didn't actually say which preventative services were covered by this special provision, and instead delegated the responsibility to various administrative agencies to flesh out the details regarding precisely which forms of preventative care would be mandated. So there's a mandate in the Affordable Care Act, in the federal statute that passed, in Obamacare, that says certain preventative services have to be covered for free to the employee, if you will. That is without these forms of cost sharing, but didn't say which ones they would be. So what happened next is the Departments of Health and Human Services, the Department of Treasury, and the Department of Labor jointly issued a regulation that specified that the mandated preventative care would include certain women's services, which would be announced a year later, in August of 2011, by another sub-agency, which hadn't previously existed, called the Health Resources and Service Administration. So you see, you have the federal statute, which says you must provide certain preventative services without cost sharing, which delegated the authority to say which ones would fall into that category, to the HHS, Treasury, and Labor, who then delegated that authority to a sub-agency, HRSA, who then said, we're going to delegate the authority or the responsibility to flesh out which services should be covered to a non-governmental body called the Institute of Medicine, which would then put together a 25-person subcommittee which held hearings and had a conversation about which women's services should be covered, which preventative services for women should be covered. And there was a great deal of anxiety in certain quarters that this group, this small group of the Institute of Medicine, would not take into account religious freedom and conscience in crafting the task that they were charged to do. And in fact, the dean of the Public School of Health at UCLA, who chaired that commission, was asked directly, what about religious freedom and conscience? Are you all thinking about that in your deliberations? And her answer was, we don't take into account personal opinions or feelings. That was her response. And that was an ominous response, and as you'll see momentarily, that the result was pretty much what that response betokened, which is there was no exceptions for religious liberty. August 1st, 2011, HRSA received the recommendations from the Institute of Medicine and adopted them in their entirety. And in relevant part, for our purposes, the guidelines required all health plans that were not grandfathered in, that's a term of art we don't need to talk about or worry ourselves with. They require health plans to provide all Food and Drug Administration approved contraceptive methods, sterilization procedures, and patient education and counseling for all women with reproductive capacity. So that means every employer who is subject to this law, which is many, many, many employers, all employers over 50 employees, if they're not grandfathered in, would have to comply with this directive. And that gave rise to two major concerns that were raised immediately in response. One I'll call the pro-life concern, and the other one I'll call the religious liberty concern. The pro-life concern we won't talk about. We can talk about it in conversation if you like, but we'll focus on the religious liberty question today. But the pro-life concern was that some of the agents that must be provided by virtue of this mandate do, according to the FDA description of their mechanism of action, or might function by destroying the living embryonic human being before or after he or she implants in her mother's womb. And the agent that raised the most concerns in this respect was ELA-1, or the so-called week after pill. And if you look at the FDA labeling, the mechanism of action says this is contraindicated for pregnancy. In animal models, it causes termination of pregnancy. It might function by preventing embryos from surviving in vivo. And so pro-life folks like myself were deeply concerned that was a major flaw, to say the least, in the mandate. But the other concern is that the mandate would force some employers to facilitate behavior that they hold to be gravely immoral, either in light of their moral principles or religious views, thus severely diminishing their efficacy of public witness of the truths to their faith in certain cases, or in some cases actually involving them directly in the provision of these objected to services. Now, there were some additional concerns raised that the process by which this mandate was imposed was deeply flawed. There was a lack of transparency and accountability. That is, Congress has tried 24 times to do what this mandate did and failed, couldn't muster the votes to do it, but instead, this was accomplished with administrative action through delegation of a sort of broadly worded law, and so that people have objected to that. That is a kind of gravely flawed form of governance. There are concerns about irresponsible social engineering. Did they think it through? Did the IOM think it through? Did they take into account costs and benefits? They actually, if you look at the report, it's pretty spare. Concerns about novel and sweeping forms of coercion. The scale of this is system-wide. It's a federal-wide mandate. And then also a deep concern is that insofar as you make it more difficult for the organs and the institutions of civil society, those private associations that we sort of form together to try to contribute to the common good, the harder you make it for those to be distinctive and to integrate their deeply held principles with their operations, the harder you make, the sort of more impoverished the landscape will become, because people will move, these institutions will move out of the public square, or they won't form to begin with, or they'll shut down. So, August 3rd, 2011, there was an additional rule published that said we're going to provide for a religious accommodation that respects the unique relationship between a house of worship and its employees in ministerial positions. And the rule that they came up with, the initial rule, was quite narrow. It said houses of worship, narrowly defined as churches and their auxiliaries, and will be exempt. Religious institutions like Notre Dame, schools, hospitals, and social services would be subject to the mandate without exception, and everyone else, including private individuals and companies and family businesses, would also be subject to the mandate. There was an initial bipartisan reaction, which was in some ways surprising. Opposition, strong opposition to the mandate, which included a wide spectrum of Catholics. And as you all know, it's hard to get Catholics to agree on much in American politics, and which is problematic. But in any event, there seemed to be agreement at first that this went way too far. We should push back against this. And HHS reacted over a period of time. Its initial reaction on January 20th, 2012 is, we're not going to change anything. You'll have a year to get your affairs in order. Their second response was, well, we'll come up with some sort of accommodation for those religious entities like schools, social services, and hospitals that will address their concerns. A year later, there was an advance notice of proposed rulemaking, which again was essentially a brainstorming document. It said, well, we think that here are some possibilities for those kinds of entities. That was fleshed out into a notice of proposed rulemaking in February 2013, and then the final rule was issued in June 2013. And the final rule, and this is the last, I'll conclude and then turn the mic over to Professor Garnett. The final rule modified slightly some of the language in describing which kinds of houses of worship would be totally exempt, but it's still quite narrow. You have to be a house of worship or its auxiliary that files under a particular provision of the Internal Revenue Code that is reserved for houses of worship. It offers some provisions for non-exempt religious institutions like Notre Dame and others that govern the manner in which they must facilitate coverage of the objected to drugs and services. So there are some modifications that sort of create a framework within which we're compelled to facilitate these things. But for our purposes, the most important feature is that private businesses and private individuals were left with no relief at all, no protection at all under this framework. And that has given rise to numerous lawsuits and reactions, and my colleague, Professor Garnett, who is the leading expert on this question, will elaborate further.
Great, thanks. Thanks, Carter, for setting that up. Thanks very much to Tocqueville and to the Center for Ethics and Culture, and for all of you who've been so generous in supporting these great efforts here at Notre Dame. Thanks also especially to the students for coming out early on a Friday morning on a football weekend. So about 18 months ago, it's sort of a deja vu kind of sense, at another similar event in the law school, Professor Sneed and I and a few others participated in another panel discussion also about the HHS mandate. And here we are again a year and a half later. Now at that point, most people's focus, certainly mine, was on the application of the HHS mandate to religious institutions, such as Notre Dame or various dioceses or so Catholic welfare agencies, Catholic newspapers, religious colleges, and so on. And as you know, a whole bunch, that's a technical term that we lawyers use, a whole bunch of institutions have filed lawsuits challenging the application of the mandate on religious freedom grounds. These cases are pending in various ways. Right. Now, we didn't talk very much then, but we're talking a lot now about the fact that the mandate also applies to for-profit businesses. I think a year and a half ago, again, that wasn't the discussion, right? The focus was much more keyed in on institutions like Notre Dame, on parochial schools, and so on. When private businesses were addressed, they sometimes got the back of the hand. It was, some commentators would sort of dismissively refer to the Taco Bell problem as being like, well, how could we possibly exempt Taco Bell from the mandate? Well, as it happens, for a number of interesting reasons, the cases involving for-profit businesses have actually gone further than the ones involving religious institutions, and part of that is because of the various regulatory things that have been going on that Professor Snead just described. But with respect to the for-profit plaintiffs who have challenged the application of the HHS mandate, they're staring the applicability of this mandate in the face, and 37, I think 37, I counted, I checked online yesterday, 37 of the cases, of the 67 or so cases, actually involve for-profit businesses. Now, interestingly, so far, and the count keeps changing every day, there were a couple new decisions this week, but about 30 of the 37 cases that involve private businesses have resulted in what we lawyers call preliminary injunctions for the parties who are challenging the law. Put differently, the parties are winning. Limited wins, right? Provisional wins, but wins nonetheless. Right? And of course, in several cases, they've lost. What it means to get a preliminary injunction isn't that you take your trophy and you go home. It simply means that the mandate will not apply to these employers that have won while the litigation is proceeding through the courts in its Dickensian way. 3 cases so far have made it to the Federal Court of Appeals level, which, as most of you know, is the level right below the U.S. Supreme Court. The latest case was handed down just this week by the Court of Appeals for the Sixth Circuit. The Hobby Lobby case, which has probably received the most attention, was decided by the 10th Circuit Court of Appeals, and that was a win for the challenger. Right? So Hobby Lobby was successful in getting a preliminary injunction, in convincing a federal court that the mandate might well violate the Religious Freedom Restoration Act. And then in 2 other cases, one's called Conestoga Wood out of the 3rd Circuit, and one's called Autocam out of the 6th. The challengers lost, and their arguments were dismissed. An interesting development has happened this week where in 2 of the cases, petitions have been filed in the U.S. Supreme Court. In the Hobby Lobby case, the administration is saying to the Supreme Court, we want you to review this issue because we lost to Hobby Lobby. In the Conestoga Wood case, the plaintiffs are asking the Supreme Court to review the case because they lost to the administration. So the issue is joined, and it's been joined faster than I expected. There's a possibility, not a slam dunk possibility, but a decent possibility that this case could be heard and decided during the court's current term. So stay tuned. Now, as you might know, you wouldn't know this from listening to Professor Snead because he's so clear, but usually lawyers like to take straightforward questions and make them more complicated. And professors like to take straightforward questions and make them even more complicated. So law professors love to take straightforward questions and twist them into knots, and so I'm going to do a little bit of that. I want to take Professor Munoz's admirably clear question, can and should for-profit businesses claim conscientious objector status, and pick it apart a little bit. First, I think it makes sense to clear the deck a little bit and to be clear about what we're not talking about, at least what we're not talking about today. Our question today is not, I hope, merely whether or not we like the Affordable Care Act or whether or not we prefer the Democrats to the Republicans or vice versa, or which political label we attach to our cluster of beliefs. It's not whether we think that all things considered an employer mandate mechanism is better or worse than, say, a single-payer mechanism. And I don't even think the issue is whether we embrace the richness of the church's teachings on sexuality and marriage and family and the moral status and dignity of unborn children. Obviously, all of those are crucially important questions, but I want to really focus in on the one that Professor Munoz has given to us today. I think the focus today is on two pretty specific, and as I said, very timely questions. First, does a particular federal law, the Religious Freedom Restoration Act, does it apply to claims that are brought by for-profit businesses? Does it apply at all? And second, should the law sometimes provide accommodations to for-profit businesses, as it does to individuals, that have religious objections to certain legal requirements or prohibitions? So again, to be clear, our agenda today is not to talk about the scope of the limited exception for houses of worship. There's going to be litigation about that. And we're not talking anymore, at least not yet, about the application of the mandate to institutions like Notre Dame and how the so-called accommodation will play out, right? If you're interested in my views on those topics, there was an op-ed that I did in USA Today about a year and a half ago now that says some things about what I think on those questions, and we certainly can talk about it in Q&A. But let's talk about this law, the Federal Religious Freedom Restoration Act. This law was enacted 20 years ago, and this might sound impossible to believe. It actually kind of is difficult to believe when you remember it. It was passed unanimously by the House of Representatives, unanimously. And it wasn't because everybody in the House was of the same party. The House was nearly split down the middle. It passed 97-3 in the Senate. Right? The Senate can't agree what day of the week it is, but they passed 97-3, a rule that provided substantial religious freedom protections and generous rights of exemptions to persons. We'll talk more about what that means. Now, this law was a response to a Supreme Court decision called Employment Division versus Smith. Many people believed, many still do, that that case cut back on the protections that the Constitution's First Amendment provides. So Congress said, well, if the court's not going to use the Constitution to provide as much protection as we think should be provided, we'll do it ourselves. We'll enact a federal law, and that is the Religious Freedom Restoration Act. So we have a statute on the books. It's been upheld by the Supreme Court insofar as it applies to the federal government, and its purpose is clear. Its purpose was to provide more protection for religious liberty than the Constitution provides. Its purpose was clear. It was to give people who object, even to generally applicable, neutral, constitutionally valid laws, give them a right to be accommodated, to be exempted, to opt out. The Religious Freedom Restoration Act represented, in other words, a decision, a near unanimous decision by our Congress, that religion and religious exercise and religious conscience are worth protecting, even if it takes some cost to do so, even at some inconvenience, even when the objections in question are raised against laws that people think are good ideas, as is often the case. Right? If you think about it, actually, the Employment Division versus Smith case that so aroused Congress's anger, that involved a challenge to the drug laws. Now, I'm pretty sure that the near unanimous Congress that passed the Religious Freedom Restoration Act wasn't trying to signal their disapproval of the drug law regime. Right? They weren't suggesting we should repeal the entire Controlled Substances Act. They're all on board for our laws regulating drugs, and yet they said religious freedom, religious exercise is important enough that if we can accommodate the use of some hallucinogenic drugs by some Native American religious groups, then we should. Now today, this act is controversial. Today it wouldn't pass. Think about that. Today the Religious Freedom Restoration Act wouldn't pass. And certainly, even if it squeaked through, it wouldn't pass unanimously. There'd be too many worries, too many kind of bugaboos lurking in the minds of some representatives that this would enable religious groups to stand in the way of important public programs. Nevertheless, it was enacted. It is the law. What does it say? The law provides that the federal government, quote, shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. Even if it's a general law that applies across the board, even if it's neutral, non-discriminatory, the federal government is not to substantially burden a person's exercise of religion. Unless, and here are the conditions, that burden is in furtherance of a compelling government interest, and it's the least restrictive means of furthering that interest. So let's translate that. Federal law says that the federal government, basically the federal government is saying to we the people, we're not going to do this. We're not going to burden religious exercise unless we have to. If we can avoid imposing such a burden, we will. if we can accommodate religious objections, then we will. So, does this law apply? Does it provide protections to for-profit businesses? As I see it, there are three reasons why we might think that private entities like Hobby Lobby should lose. I think it's important to get those on the table if we're going to consider whether we think they should win. First, one might say, as the Sixth Circuit said this week, that such entities don't count as persons. Right? The Religious Freedom Restoration Act protects persons. For-profit businesses are not persons. Therefore, case done. We don't have to get into the question about how big is the burden and how possible is an accommodation. Right? The law is only triggered on this theory by a burden on a person's exercise of religion. Second, we might say that a rule that applies to a business entity, like Hobby Lobby, does not and cannot impose a substantial burden on the exercise of religion. Why? Because even if a corporation, even if a business entity is a person, it can't really exercise religion. Or its religion can't be burdened in any significant way by a law of general applicability. Right. Now, relatedly, we might say that a mandate which applies to a business as such shouldn't be regarded as imposing any burden on the owners or the managers of that business, even if it's a closely held or family-owned corporation. Because, after all, on this theory, the entire purpose of corporate law is to separate the business from its owners. And the third argument against Hobby Lobby's case would go something like this. It would say, even if the mandate imposes a burden, and even if that mandate is substantial and it falls in some way on religious exercise, that burden is necessary and justified. There's no way around it. Right? Providing universal health coverage, and more particularly providing preventative services without cost sharing, this is such an important interest, and it can't be achieved in any other way. If we started letting businesses opt out, the system would fall apart. Right? Accommodation would be too expensive. Now notice something. Even if the act applies to some businesses, and even if businesses can and do exercise religion, and even if some rules do burden a business's religious exercise, this doesn't mean that every business's claim will win. Right? It might well be, it probably should be, that we make some fine-grained distinctions between a publicly traded huge corporation like Walmart and a family-held business, a closely held business like, say, Conestoga Wood or some others. Right? So even if businesses are persons within the meaning of the act, there's still a lot more discussion to be had about whether or not they should win. Now, let's start with this first objection about person. Right? There's another federal law. It's got a great name. It's called the Dictionary Act. The Dictionary Act says this: with respect to any act of Congress, the word person includes, quote, corporations, companies, associations, firms, partnerships, societies, as well as individuals, unless the context indicates otherwise. And that's when we lawyers start, rolling up our sleeves, and those of you who pay the bills start, rolling your eyes, right? Unless the context indicates otherwise. This is what has divided the court so far. The Sixth Circuit this week said, well, the context of the Religious Freedom Restoration Act suggests that they didn't mean to cover business corporations. And then in the Tenth Circuit, the Hobby Lobby case, the court said, well, no, there was nothing in the congressional debates that suggested any intent to exclude businesses. And in fact, if you look at the context of religious freedom law generally, business entities and employees in the business context are often protected by religious freedom protections. So we should assume that Congress meant to continue that practice. And this is one of the things the Supreme Court, in a very kind of lawyerly way, will have to work through. Right? Now, I want to give the objection, the not persons objection, its due. Right? There are reasonable arguments going that way with respect to context. But on the other side, and what I think are the stronger arguments, here's a few points that are worth making. First, it has to be the case that some corporations and corporate entities are protected by RFRA, right? It has to be that, say, the Diocese of Chicago, the Archdiocese of Chicago is covered. So no one could plausibly maintain that the Religious Freedom Act only applies to natural persons and doesn't apply to anything but natural persons. That's a non-starter. So right off the bat, the question is not, does it apply to corporate entities? It's which corporate entities does it apply to? A second thing we should keep in mind is that it is well settled that business entities are protected by the Constitution. Right? Think about protections against unconstitutional searches and seizures, right? Or protections against excessive fines, or indeed protections afforded by the free speech clause. Business corporations enjoy these rights. So it seems to me that the burden is on, if you want, the other side, right, the side defending the mandate, to say, why is the right to religious exercise different from the right to privacy in your papers and effects or the right to freedom of speech? Third point, corporations, business corporations, can and do stand for things all the time. They might be doing it disingenuously or because they want to pander to certain consumer groups. But the fact is, if you ever watch television, you know that businesses all the time want you to think that they stand for certain things, right? Like recycling or the Chicago Bears or what have you, right? So the idea that businesses don't do anything but money stuff isn't descriptively accurate, and that shouldn't control the case either. And fourth, even if the business itself, a for-profit business itself, at the end of the day, isn't held to be a person, it still could be the case, and in some cases I think it should be the case, that a regulation which appears to fall only on the business actually falls on the people who own it, right? Especially in a family or a closely held type business. Now, once we get past the question of applicability, then we get into these tricky questions about accommodation. Right? Is the measure in question the least restrictive way of serving a government interest, or is an accommodation possible? This inquiry requires balancing, right? Requires weighing costs and benefits against each other. This is always the case. And I think if there's any sort of takeaway, as our friends in the business school would say, that I'd like for us to have today, it's that we should not think, and we should encourage our friends not to think, that the mere fact that we're in the business or the economic or the livelihood or the work sphere means that the balance is done, right? That religious exercise loses, that the religion sphere is somehow a conscience-free or a religion-free zone. Again, remember, the Religious Freedom Restoration Act has as its premise that religion is valuable and special and worthy of accommodation, that such accommodation should happen even when they're inconvenient and costly, if possible, right? After all, it's costly to respect constitutional rights all the time. Because we believe in certain criminal procedure rights, we sometimes let criminals go free. Right? Constitutional rights aren't cost-free, and religious freedom isn't cost-free, and Congress didn't think it would be. There's not a bright line, and you're going to hear more about this in the next panel, that separates the private realm of religious belief from the public realm of religiously motivated action. Right? And that's because we are, to use the word that Professor Sneed used, we are integrated beings. Right? We are social beings. We live, move, act, and believe and worship in community as well as in private. And any kind of legal argument in this RFRA context that tries to sharply divide these sectors, it seems to me is not true to the truth of what we know to be, or what we know the truth is about the human person. I want to conclude, I'm sorry I've gone on a little longer than I planned, but just with a thought about what Professor Sneed and I and others do at the Notre Dame Law School. One of the things that we try to do, this is kind of a speech I give to my students at the beginning of the year, is we encourage students, some schools discourage this, we encourage it, to bring with them into law school their values, commitments, ideals, belief, and faith. And the idea is you bring that stuff with you, you're a whole person, you study law as a whole person, you become a lawyer, and you leave with those same values, beliefs, commitments intact, and you take them out with you into the world, into your vocation in the law. And law is supposed to be a vocation. Right? And I think underlying this debate about the mandate, there's a point that's simple and clear, and it's just like the point that I present to my students about legal education. Just as my students have a right to study law and then practice law as whole and integrated persons, I think we all have a right, and federal law recognizes this, to live, move, act, and work in the public sphere, in the economic sector, right, in the market sector, as whole persons. This doesn't mean that every religious accommodation can be granted or that every religious liberty claim will win. Some won't. Right? But our animating and overriding commitment should be to respecting and facilitating the integration of people, whether they're in church or whether they're at work. Thanks.
see why those of us who are focused on Notre Dame's mission are so proud of our law faculty. So thank you, Carter and Rick. Plenty of time for discussion. At the program in Constitutional Studies and the Tocqueville program, as I mentioned last night, we'd like our undergraduates to ask the first question. So undergraduates, I know some of you are here. I know you're not used to thinking this early in the morning, but okay, let's open it up.
We can start cold calling on people.
Exactly. That's what we do.
I know, I'm tempted to. I see a lot of my students here. Please, and will you stand up and identify yourself, please?
My name is Dick Griffin. I'm a Barker-Mead and undergraduate from class of 1960. I have a practical problem as a businessman. I appreciate all the legal arguments and ramifications, but we have a company that has slightly fewer than 50 employees. And of course, this Obamacare is a disincentive to grow, and that's a whole other subject. But we're not given a pass until 2014. We have to comply with this Obamacare law effective January of 2014. It's coming January. So we're just a few months away. We do provide health insurance to our employees, a very costly program. We want our employees to have health insurance. We don't want to get into a lawsuit against the U.S. government. We spend way too much over our careers on lawyers. So we don't want to spend the money to take on the U.S. government. So we got to comply with this law coming up. So what do we do? What do we do as a Catholic businessman? Well, what we're probably going to do is drop the health care coverage that we provide and have our people go into the exchanges and buy their own health insurance. And we will give them a raise so that they can buy health insurance. Most of them make on the order of like $45,000 a year, so they will qualify for government subsidies. So we'll probably not have to give them as a raise as much as we're now spending on health insurance. So we're probably going to make money. They're going to make money. Who's going to pay? It's all of us as taxpayers who are going to pay the difference.
Great, thank you.
So that's my comment, and that's I don't know what's the question or what.
Let me just sort of quickly, just so make sure everyone could hear, and I'll ask the panelists to weigh in on this. What Mr. Griffin is saying is that there's an incentive for him as a business owner to actually drop health care coverage for his employees. Carter, do you want to speak on that?
I was just going to ask a question, clarifying. Mr. Griffin, what state do you live in? Michigan. Will there be exchanges in the state of Michigan?
Yes,
They're working on it now. Do they know when they'll be online?
supposedly October 1st.
Supposedly
Trying to get through to the
this October 1st.
this October 1st. I can imagine trying to get on the telephone to go in and get prices for all our employees as to what it's going to cost. Can you imagine what this is going to be like?
It's going to be quite an onerous process for everybody, assuming that the exchange gets up and running, and also assuming further that the subsidies to pay for the exchange are actually in place and sufficient and lawful, because there are serious questions about whether or not the fees that were created by regulation to fund these exchanges are in fact consistent with the statute itself, or if they'll be funded by Congress. So there's a lot of difficult questions. I mean, I think this is more of a question.
Our Michigan will not be a state exchange, it will be a government exchange, and you're right. There is a question as to whether the U.S. government has to provide these subsidies for a state that doesn't have its own exchange.
Right, and so the exchanges have already been delayed once, right, in terms of getting, the OPM is going to have to set up the exchange in your state, and it's not at all clear to me that they have the resources or the organization to do that, which adds that's just adding a different layer of concern to what you've already laid out. I mean this question is all I can do is express sympathy for a conscientious business owner who cares about the well-being of his or her employees, of how to grapple with this question, the regulations and the incentives that are embedded within those. It sounds to me like you've got a lot of very difficult choices to face.
And those are just part of the law, right? I mean, there's no easy solution to that.
Yeah, I mean, this is not what we talked about, Professor Garnett or I, but the question of the incentives and deterrents that are built into the law in some ways. If you want to compel employers to provide health care, you'd want to have a bigger penalty than $2,000 per employee, because in many cases that's less than what it costs to cover the employees. John Deere and Caterpillar and others came forward and said, it'll be $2,000 fine per employee not to cover them. It's more than that to cover them. We're going to drop them and send them into the exchanges, which is quite an unstable and unpredictable thing. If you don't qualify for a subsidy, if you make more than, I think the number is 400% over the poverty line, then you have to pay to go into the exchange, and the average cost of the exchange for a family of four is $18,000, and it's coverage that generally is regarded as more stripped down than what most employers provide.
Carter, do you know, or Rick, do you know if a company provides health insurance but not the preventative services that are morally objectionable to some? Is there a different fine?
It's a different fine, and it's a much more draconian fine.
If you provide health insurance but no contraception coverage, you're fined more than if you just don't provide health insurance?
Dramatically more. So, for example, the Treasury regulations are what governs violations of the contraceptive mandate. So, if you drop your employee from employment, it's a $2,000 fine. If you refuse to comply with this, it's $100 per day per employee for every single day that you're in violation. So Notre Dame, for example, let's say you have 8,000 employees, it would be $800,000 a day. If you
versus $2,000
versus $2,000 times 2,000 times 8,000, and that's your answer
per year.
Per year, exactly. Right. This all assumes that you're subject, and this is actually something that Professor Garnett has talked about before. The mandate, the HHS, or the law, the Affordable Care Act, is riddled with exceptions and waivers. In fact, there are over 1,000 waivers that have been given to the entirety of the act itself at the discretion of the Secretary of Health and Human Services. In fact, one of the observations that was made, and I'll just report the observation, you can judge for yourselves what it means, is that a significant percentage of those were in the district of the Speaker of the House at the time. And in fact, now unions are complaining bitterly about the function of the mandate on precisely the sorts of worries about giving people access to health care in a sufficient way. And they're meeting with the White House right now to try, and people think that they're trying to negotiate a waiver for themselves. So it's, in some ways, the waivers are this apparatus is shot through with waivers and exceptions, which leads one to think, which I think relates to the question of the least restrictive means, or even the question of general applicability and neutrality of this law. So, which has religious liberty implications that Professor Garnett is an expert.
There's a lady in the back, maybe. Stand up and tell us who you are.
Margaret Kennedy, I graduated from the May. And I'm just wondering about, with the corporate veil, how are the liability, so the whole intent is to limit the liability of the managers and owners of a company. And I'm wondering how the corporate veil differs in terms of large corporations versus small corporations. What's the extent to which the legal liability is limited for an owner-manager of a closely held corporation?
Let me just restate the question so everyone can hear it, make sure I understand it as well. So, questions on corporate law and the liability and differences between large and small corporations. Rick, can you address that?
Yeah, I'm a little nervous about it because I don't teach corporate law subjects, and I think some of my colleagues in the room here do. But just basically, I'm going to agree with the premise of what you say, which is to say it is kind of the bedrock point of corporation law to facilitate commerce and to facilitate exchanges in the market by separating ownership and management. Right? And by creating these, making it possible to have liability, in a sense, stop with a corporation and not run through to everybody who owns an interest in that. The law distinguishes among different kinds of corporate forms, right? Some are huge and publicly traded, some are huge and not publicly traded, some are small and closely held, and so on, right? But I think for your purpose about the corporate veil is one that applies kind of generally, and it's an interesting image, right? Because sometimes you'll hear people talk about, quote, piercing the corporate veil. And what this refers to is that sometimes in some legal contexts, the law will say, we see that it looks like there's a corporation here, but we can see kind of behind the veil that what's really going on is there are private individuals who are actually controlling everything, right? And so we're going to pierce the veil, cut through it, and get at them for some kind of liability purposes. And that happens in a variety of contexts, and there's various standards that have to be met to do that. What some people who oppose the religious liberty claims that I was talking about today will argue is to say, look, remember the corporate veil? Remember the whole point of corporation law? If a mandate applies to a corporation, by definition, it's not applying to the people who own it, and so they're not experiencing any burden at all, right? The owners of Hobby Lobby aren't providing access to abortion-causing drugs. It's Hobby Lobby that is, and there's a difference, right? There's an interesting argument that's been made by a professor out in California, Steve Bainbridge, who's an expert in corporate law. And he talks about what some people have called reverse veil piercing, and that is when the owners who might ordinarily want to be kind of behind the veil and separate from the corporation that they're using as a vehicle, actually, they part the curtains and say, no, wait a minute, what's happening to that corporation is really happening to us. And they're making that argument in the Religious Freedom Restoration Act context. So.
Okay, I'm sorry, I've been ignoring this side of the room. Please.
Question. Little is being said about the enforcement of these laws once they become finalized and enacted. Although I believe there's been some discussion about restricting funds to the IRS so that they would not have the manpower to enforce this law. Do you think that this has any bearing on the quote, least restrictive means of providing coverage?
Okay, Merv's question, Merv and his wife are some of our frequent supporters, so it's great to see you here, is about the enforcement of these provisions or perhaps the lack of enforcement of these provisions. Any thoughts about that?
I think the way the least restrictive means inquiry would go, I think, is something more like this. A court would ask, what's the important interest that the preventative service mandate is trying to achieve, right? And that interest, for purposes of litigation, will be providing the services to women without cost sharing. And the court will say that that's a compelling interest. They almost always do. They don't get into second guessing the legislature. They'll say, okay, so that's an important interest. Is there a way for the government to pursue that interest, right, to achieve its goal in pretty much as effective and efficient a way that doesn't burden people's religious exercise, that doesn't burden businesses or individuals or religious institutions' exercise? And what that question will turn on really is something like, how feasible is it to get the coverage to employees whose employers object to providing it? And you can go online and actually read the briefs that some of the parties have filed, including Notre Dame, and they point out, look, yes, there are lots of other ways the government could do this. Let's not fight about whether the government should be doing this. It's decided to do it. Congress decided to do it. Here are some other ways you could do it. For example, you could just say, if you're an employee of Notre Dame or some other business, some other employer that doesn't want to provide the objected to service, then you get a voucher from the government that says this voucher good for preventative services, and you take it to wherever you want, right? Or you make some adjustments, say, to the Medicare law, which provides that if people who are employees of employers who don't want to provide the coverage, they can get it through Medicare, right? So the issue in these cases isn't really whether or not particular employees are going to get these services. It's not about access to these services, in my judgment. It's about who and how, who's going to pay for it and how it's going to be paid for, right? Now, there are some alternatives that a court would say, I think, look, that's not a feasible way of doing it. I mean, you couldn't, if it were 50 times more expensive to do these alternative ways, then the claimants would probably lose. But the argument's been made, and I think it's pretty persuasive, that it actually wouldn't entail a significantly greater administrative burden, given all the burdens that the government's already under, to provide the objected to coverage in different ways. I mean, realistically, there aren't going to be that many employers who would want to invoke the exemption anyway.
Yeah, and I mean, this is, I mean, I think Professor Garnett is characteristically right about this, namely, there's a real disagreement of principle here. This is, I mean, between the supporters of this regulation and those who oppose it. I mean, you can see already in the way the law is structured a radical sort of stratification of different kinds of people, entities, and the kinds of treatment they get under this framework. And it's never been seriously entertained by the administration that private businesses have any religious liberty interests in this context that they could pursue to avoid the strictures of this requirement. So the question of who pays and how is really what the disagreement is about. But there are some facts that are important to take into account when determining whether or not a particular burden is the least restrictive means. And in this context, just as a background fact, we already subsidize contraception to the tune of billions of dollars a year under Title X. We have clinics that are heavily subsidized. There are free clinics that give contraception. And if you go online to Planned Parenthood, it will give you a roadmap as to how to get contraception, oral contraception, from anywhere ranging from $9 a month to the least expensive to most expensive $90 a month, $3 a day. And it seems to me that actually goes to the question of compelling interest and least restrictive means, because how important is it to burden these people who are objecting? And Professor Garnett will correct me if I'm mistaken about this, but the question about compelling interest is not, is this law as a general abstract matter a good idea, or is it a good thing that we're trying to pursue here, but rather is the burden on these people, is the interest to burden these particular objecting individuals a compelling interest?
And this is going to bring us back to Bill McGurn's points last night, too, right, about why these laws it's being pressed so hard.
And let's imagine a different kind of case, because this comes up a lot. It will be argued in the context of these HHS cases that it doesn't make sense, indeed it's inappropriate to exempt private businesses on religious freedom grounds, because after all, we don't exempt huge landlords from Fair Housing Act requirements that they not discriminate on the basis of religion, right? We don't allow Walmart to discriminate, to use its, let's say a company had a religiously motivated reason for not wanting to hire women. They lose, right? So there are lots of federal laws and lots of mandates that apply in the business sphere that apply whether or not you like them and whether or not you like them for religious reasons. Right. And so in this context, people will often say, look, if you win on this HHS case, then what's going to stop, and then list the parade of horribles. And that's not a crazy thing to worry about, right? I mean, we need to be candid here and accept the fact that it will be the case that in the economic sphere, not all religious objections to all federal laws can or should be given. In this litigation, the question is really more focused, right? It's that this seems to be a case where an accommodation is possible, it's affordable, it wouldn't do damage to the goals of the law in the way that, letting Burger King decide it doesn't want to hire women would damage the employment discrimination laws. Yeah,
and just to add to that, I mean, this is that balancing. Professor Garnett said something very important, namely, our tradition is to give accommodations when we can, to accommodate religion, and that's reflected in the Religious Freedom Restoration Act. And sometimes people will say one parade of horrible that's sometimes rolled out, or one participant in the parade of horribles, maybe the twirling guy at the front of the parade of horribles, is the Christian Science Monitor stopping giving medicine to its employees. If we accept this, then we have to accept that. And the answer is no. This notion of balancing is embedded in the Religious Freedom Restoration Act itself. The notion that the government, so you have a presumption that your religious liberty won't be substantially burdened, but there may be instances, as Professor Garnett points out, where the government says, look, this is a compelling interest, and this is the least restrictive way of pursuing it. And in that case, the balance is struck, and we can make distinctions, as reasonable people do all the time, between something like this, which it seems there are less restrictive ways of achieving these goals if these goals are good goals, and sort of more draconian hypotheticals involving the Christian Science Monitor.
Yeah. Please.
I try to teach at this university. This is a damn foreigner's question. As well as the religious liberty concern and the pro-life concern that Carter mentioned explicitly, there's obviously a third concern involved here, which was implicit in Carter's introduction, which is a democracy concern about what seems to
To me, in a country that is so invested in its historical role as a model democracy for the world, anomalous that Congress can delegate such an important part of its legislative responsibilities to a bunch of bureaucrats and technocrats. I know this is, a dumb question. It comes from a foreigner who doesn't really understand the United States. But is it not possible, to challenge the legislation on those grounds? Does Congress really have an unlimited right to abdicate its responsibilities under the Constitution?
Well, Professor Garnett teaches constitutional law, and we'll be able to flesh this out more clearly. But we have. I mean, it's hard to unring the bell of the administrative state. We did it. There was at one point a very serious question, and many people are deeply concerned about it, about delegation. What's the authority of Congress to delegate its responsibilities and its political accountability, by the way, which is a very convenient thing for Congress to do, to hand it off to bureaucrats and ask people who the Secretary of Health and Human Services are. Everybody in this room knows the answer to that, but most people don't. And what was the regulation that she propounded with respect to this question? There's a kind of, and there are actually congressmen and senators who said, if I knew she was going to do this, I never would have voted for the Affordable Care Act. Now, in principle, if an administrative agency goes off the reservation and does something that is not even plausibly contemplated by the statute, then you might have an issue. But that's a very, very high bar, because most statutes are written at a pretty high level of abstraction. And the point of administrative agencies is not just to enforce the law, but to use their law-like or legislative-like authority to propound regulations that fill in those gaps and give content where Congress meant to. So it's. I mean, I understand the concern is a very serious one, but this is a problem that came up a long time ago. And if you go down to Independence Avenue and you see all the administrative agencies, it'd be tough to undo it. So the question is, how far is too far? And Professor Garnett, teaches these sorts of questions.
Yeah, but he already told you everything. I wish I could bottle that zeal for our constitutional structure and hand it out like in little bottles to all those students. It's just,
you need a bigger bottle.
Yeah, sure. But the question is a serious one. On the one hand, it's water under the bridge, it's over the dam, the genie's out of the bottle, whatever. We have an administrative state, it's not going away. And it's true that the administrative state is in some tension, at least in some of its reaches, with, I think, the structure of the Constitution as it was originally conceived. That said, it would be impossible for Congress to legislate with the specificity that's required in order to make laws workable. Right? I mean, look at Congress. They couldn't do it. Right? So you have to have agencies. And agencies can and do work consistently with the Constitution often, I think, when they really are just implementing what Congress has done. And the courts, the Supreme Court, has basically decided, look, so long as Carter put it, so long as what the administration is doing is basically carrying the water that the Congress gave it, we're not going to second-guess those decisions. Interestingly, in the HHS litigation, some of the plaintiffs have raised administrative law challenges. Some of the plaintiffs have said, in addition to all the religious liberty problems, the process by which this preventative services mandate was promulgated doesn't comply with even the kind of rigmarole that's required by the Administrative Procedure Act. Those aspects of the challenge haven't received much attention. They haven't been in the news. Courts haven't talked about them. But the issue is out there.
Let me just add one last thing to this. I don't want to upset you further, but if you look at the process by which this was achieved, first of all, as I mentioned, Congress tried to do this on 24 different occasions and failed every single time because there wasn't they didn't have the political support for it. So they've accomplished, so that you would think there used to be some kind of internal side constraints on what a Secretary of Health and Human Services is willing to impose, knowing how politically controversial it is. So that's a pretty brazen thing that HHS and the other agencies did. The other thing that's even more worrisome is Secretary Sebelius was asked directly, did you guys get an opinion from the Office of Legal Counsel or the Department of Justice on the question of whether or not this comports with the Religious Freedom Restoration Act or the First Amendment? No. I'm not a lawyer, I think was her response. Well, we have lawyers in the federal government. We have a lot of them. And we have an attorney general. And sometimes you're supposed to ask them, is this thing that we're about to do consistent with federal law and the Constitution? She admitted that that question had not been presented nor reflected upon. And then if you also read the Institute of Medicine report, which was adopted whole cloth, by all the agencies straight up the chain, there are serious flaws. They didn't ask any questions about costs. They didn't entertain questions about alternative possibilities to produce this. They didn't even ask real questions about the public health consequences of allowing an accommodation for objecting entities, especially on the small scale that it would likely be. There's a dissent by an economist in the IOM report, which I would commend all of you to read, who himself says, I'm in favor of spreading contraception around, far and wide, but this isn't social science that we're doing here. This is just political ideology, loosely and packaged in the form of an expert report, and that became our policy. And now we have to live with it. And so I think this is a particularly sloppy example and a troubling example of an administrative agency exercising its authority.
Just for my students in the room, this is exactly what we were talking about in class yesterday. Locke and the delegation of legislative power. It's a particular manifestation of exactly what Locke was talking about 400 years ago. Okay, please.
Liz York, I don't know but big supporter of NAPA. Knowing some of the plaintiffs who have filed these lawsuits at great expense, and not to sound dramatic, but I do feel that many of them are modern-day martyrs. I mean, they're going to be, they have a target on their back, they're at great expense, they're looking at losing their lifelong business because of battling the government. But my question to you two is, in light of this effort in Congress to defund Obamacare, it sounds like we're looking at tremendous chaos. What does your crystal ball tell us what's going to happen in the landscape of the United States for the next year with everything happening both in Congress and in the courts?
With respect to the Affordable Care Act?
Let me put you both on the spot here. If this goes to the Supreme Court, what do you think happens?
Well, this is a separate question from what was just asked, though, right? So, my view, I'm not a political scientist or a journalist. I'll defer to Mr. McGurn, but Obamacare is not going to be defunded. So, I realize that it's kind of entertaining for some to see the kind of some congressmen say they're going to defund it, but it's not going to be defunded. So, I think that's kind of off the table. On these cases, boy, I'll cheat. I don't know, but if I had to say, I'd be surprised if the court agreed with the argument that the Religious Freedom Restoration Act doesn't apply at all to for-profit businesses. I suspect that they wouldn't issue a sweeping ruling saying the preventative services mandate is illegal under RFRA or it's unconstitutional under the First Amendment. But I could imagine a ruling, again, a more narrow kind of John Roberts-y kind of ruling that says, look, to the extent some courts are saying that RFRA doesn't even apply, that's wrong, right? Then that raises the hard question about you have to look at the characteristics of the particular plaintiff in question and say, is it plausible that this entity has a sincerely held religious commitment that is animating its objection to providing the mandated coverage?
And they work it out through the lower courts?
And then go back up again, right?
Yeah.
So,
I mean, there's so many different iterations of this problem, so many different kinds of corporations, so many different kinds of postures and facts. I agree entirely with Professor Garnett. I think I agree. I don't think you're the expert, but I don't think that that they would declare categorically that corporations aren't persons for purposes of the Religious Freedom Restoration Act, or that it doesn't substantially burden one's religious liberty to compel them to provide this in their health plans. The bizarre anomaly that will emerge if corporations, private businesses, are successful in court and are not compelled to provide these objectionable services in their health plans is that, and let's say the middle tier, that is places like Notre Dame, let's say that Notre Dame is not successful, or the ultimate result is that we have to, through some bifurcated process, facilitate these sorts of contraceptives, abortifacients, and so forth, or that our employees will get them through this mechanism. Then you'll have a very strange situation of the employees of Hobby Lobby not qualifying for this free stuff by virtue of their employment with Hobby Lobby, whereas folks at Catholic Relief Services, for example, would. So Hobby Lobby in some ways would have more robust religious liberty protections than would, insofar as they would have a categorical exemption, than would. They'd be treated like houses of worship, essentially, right? So you'd have a church and Hobby Lobby with robust religious freedom, and then intermediate important organs of civil society that are motivated by their religious beliefs, with less ultimate protection. And it's funny because what you hear is, I mean, in defense of all three of these tiers, you've heard the administration say, well, we're giving you an exemption, you shouldn't worry about it. For the second tier, and we're not discussing the merits of this argument, but what they're saying is, with the second tier, Catholic Relief Services, you shouldn't worry about it either because our accommodation is sufficient for you. And so why didn't you give that accommodation to the houses of worship if it's perfectly sufficient, if we're not involved at all? And then of course, the publicly held or the private companies are entirely shut out. So it's a bizarre, since you have three tiers of value to the government with respect to your religious freedom. And by the way, this is something that Professor Garnett has spoken about very eloquently. The whole structure of this sliding scale of protection for religious liberty, I mean, obviously, different people can be treated differently, and different people, the interests manifest themselves in different ways. But this notion of first class, second class, and third class citizenship vis-a-vis religious freedom is itself problematic. And it reflects a kind of very narrow conception of what religious freedom is generally. And in this whole process, the government has defended the freedom of religion, or the freedom of worship, as they describe it now, as a kind of insular, inward-looking, cloistered thing that doesn't engage in public, doesn't engage in a missionary fashion, whereas, serving meals to the poor is part of religious witness. The government doesn't seem to recognize that. They think that, no, praying in a cloister is what the freedom of religion looks like.
One thing to remember is that all throughout this, we're talking about a statute, the Religious Freedom Restoration Act, and not the First Amendment to the Constitution.
Right.
I think most people think that under the First Amendment to the Constitution, these kind of claims are not going to win. And under RFRA, they might well. One thing you should expect is that if entities like Hobby Lobby are successful, there'll be a move to amend the statute, right, to narrow its coverage. Now, whether or not that would actually get through is a question for the political scientists. But one of the things that I actually think is a good thing about having these arguments in the context of a statute rather than the Constitution is that you can be a little more nimble and a little more flexible, and that's great from my perspective when you're expanding protections for religious freedom, but there's always the danger, of course, that Congress will decide to contract it.
Yeah, especially for our students here. If you're interested in questions like this, the discussion we've been having, we launched a constitutional studies minor in 2011. We have several of our minors here. Please come talk to me about it. That minor was launched in part, completely because of the generosity of the Frank Potenziani family. And we have some representatives of the Potenziani family. James and Fred, thank you to the family. Thank you for all that you've done. This program is sponsored in part by the Potenziani program in constitutional studies. We're going to take a short break. We'll resume again at 10:30. Before we do that, please join me in thanking Professor Sneed and Professor Garnett.